do you know that Dave Chappelle skit about the black white supremacists? Yeah. Right? So he's blind. He doesn't actually know that that he hates people who look like himself. Right? So it's hilarious, but it points out this status belief distinction really well. Anybody who has the belief can organize around the shared beliefs. But if you have an immutable status and you're being discriminated against because of that status, then someone has violated your right to equal treatment or whatever that accommodation is that they're discriminating against you about. So this brings us to this case in California. UC Hastings School of Law passed a rule saying every student organization has to accept all comers. Anybody who wants to be a member of any student organization has to be allowed into your student organization, even if you completely disagree with the mission, even if you are joining it simply in order to thwart what it does and vote against all of their policies whenever something comes up, and vote in all of your friends as the leaders. Doesn't matter. I mean, they didn't add all of that part in, but every student group has to admit anyone into their group, no matter who wants to come in, as long as they're a registered student. So that means the campus Democrat president was told in a letter that she had to let anybody into her group, including the campus Republicans, to be a member, a voting member, or a leader of her group. And she couldn't have in her group constitution, only Democrats are allowed to be campus Democrats. That sounds pretty ludicrous to you, I hope. Right? Freedom of expressive association means associating around shared beliefs, having a common message, so that anybody, this is like what you said, anybody who's speaking for UVA actually is authorized to do it. Anybody who's speaking for the campus Democrats is authorized to do it. Now, what if you are the Christian Legal Society and you say, well, only evangelical Christians can be a member of our group who have the following 10 beliefs, which include being against homosexuality? Right? Well, the campus outlaw group, they call themselves, right, filed a complaint against CLS saying, this group is discriminating against us. And it kind of makes sense from a discrimination point of view, right? That, well, only people who believe this discriminatory policy are allowed to be voting members. Not only that, there's a whole category of people who are very, very unlikely to be self-hating, so that even though you're saying it's a matter of belief, it's kind of also a matter of status, because, right, you know, the Anti-Semitic Appreciation Society, if you're Jewish, you're very unlikely to be anti-Semitic, so you're kind of automatically excluded, right? So this is kind of the argument they were making. And the Ninth Circuit Court of Appeals, which, you know, covers all of California and several other states in the West, said, yeah, it is a content-neutral, viewpoint-neutral, non-discrimination policy. Every group has to follow it. So, of course, every student group does have to accept anybody who wants to come into their group. Even if it's the campus Democrats, they have to let the Republicans in, and the CLS has to let in people who have pro-homosexual views. And that's the way they're doing it. The Ninth Circuit said, yeah, it's content-neutral, it's viewpoint-neutral, it's a reasonable goal of the government to be not discriminatory, especially for the special privilege of being recognized as a student organization. So why not? Well, the problem is, everybody else who thinks about it in the country, I'm going to say it that way. The Seventh Circuit completely disagrees. 14 attorneys general, including the Attorney General of Virginia, disagrees. Although he, I think, has been a little controversial. And so you have a very strong First Amendment group on the one side, and you have a very strong anti-discrimination group on the other side. Both sides have reasonable arguments. And that's why it's at the Supreme Court, because you have a circuit split. Seventh Circuit says one thing, Ninth Circuit says another thing, and you have arguments on both sides, so you have to really think about it. But my feeling is, always, if the Supreme Court lets this rule through, it's going to apply not just to universities having what I call unconstitutional conditions, which is what the Attorney Generals call it. But it means any city or state could have a non-discrimination rule that could apply to every fraternal organization, every organization in the country. So basically, your First Amendment right to freedom of expressive association is thrown out the window. Because then any other content-neutral rule is going to also be accepted. If it's furthering some kind of government interest, government has lots of interests right? So I'm pretty hopeful that the Supreme Court is going to do the right thing on this one. Go ahead.
I was just going to point out, just for the information of the audience, that particular case was in fact, Students for Individual Liberty and Liberty Coalition. We were asked to join as an amicus on that, and it was one of those issues where we actually take ideas very, very seriously. And on one side, you know, our feeling was in favor of the CLS position, but we recognized there was also a position on the other side, and we ultimately ended up deciding not to participate as an amicus in that. The Libertarian Party, of which I serve on the National Committee, we were asked to join as an amicus on that. Again, we actually had people in our party who were strongly in favor of CLS. There were also other people who felt Hastings was doing exactly the right thing, because this is a government institution. Governments, which use taxpayers' money, should not discriminate. Of course, there's a chain of logic which I don't necessarily agree with, but I can see the arguments on the other side. So this was something that actually we had to deal with as a matter of whether or not to join as amicus.
Well, speaking of amici, I'm a member of an organization called Gays and Lesbians for Individual Liberty, and we filed a friend of the court brief on behalf of the Christian Legal Society for the very reasons you were describing.
Well, here's a great example, right? So in Boston, the Hurley Supreme Court decision, right? So, right, every year there's the Irish Parade, and it's not actually run by the city, it's run by a private organization. They wanted to exclude a gay rights group from participating in the parade. It went to the Supreme Court said, private group, that's their parade, they get to have whoever they want in their parade. Fast forward a few years, there's a group in California that's holding a gay pride parade, and an anti-gay group wants to be in the parade. And guess what? You pull out the same 9-0 Supreme Court decision saying, yes, we can exclude the people from our group, our parade, who don't agree with our mission, because it's our parade. Just like you could exclude us, we can exclude you. It's fair, right? Getting back to the CLS v. Martinez. One of the issues for Hastings is that when you have mandatory student activity fee funds, the Supreme Court has ruled those belong to the students. That it's actually the students' money, it's not the government's money. And so you don't get access to those student activity fees unless you're registered as a student organization. And so you have this mix of some government recognition, but also access to your own fees. So the Supreme Court is going to have to undo that big compromise if it rules against the CLS. So there's a lot of different things in play, and so it's going to be very difficult, I think, for the Supreme Court to undo Rosenberger, right?
That was from here.
Yes, right? Versus directors of the university, right?
Yeah.
It's a fascinating case to watch. All the amici are in. Probably the best one on the side of CLS is from the American Council on Education. And tons of groups saying that it's our academic freedom as institutions to have these policies because we think that makes a better educational institution. Why should the government come in and tell us that we're not allowed to have this policy? Interesting argument. Has some big flaws in it, which I won't go into. And then probably, I'll say that Fire's brief is the best one on the other side, because the only brief that ACE mentioned, other than petitioner's own brief, was Fire's brief, and they're attacking us, because I think they know that we have the best argument.